I quoted from Langa's statement at paragraph 159. In other words, we must evaluate the claim as it is presented to us. Langa proceeds to say there is an overlap in Chirwa's claim, meaning she is entitled to rely on subsection 2 of section 157. Chirwa pleaded her case. Now, this is important. Langa says she pleaded her case on the basis of PAJA, and it is on such a basis that her claim must be assessed. Very lucidly, Langa points out that both PAJA and LRA are protected constitutional legislative instruments that protect constitutional rights and principles. A litigant is entitled to the protection of both these rights. In other words, a right in terms of the Constitution, Section 23, right to fair labor practices, which is protected by the Labor Relations Act, and your Section 33, right to just administrative action, which is protected by PAJA as such. And then from paragraph 180, it's interesting to see how Langa adopts a very didactic, practical approach to applying all the provisions of PAJA from section 1 in order to determine whether or not Chirwa's dismissal amounted to administrative action in terms of PAJA. He looks at the relevant parts of the definition in terms of when asking whether her dismissal took place in terms of any legislation. He says that the dismissal did not take place in terms of statutory authority, but in terms of contract. And for this reason alone, it cannot amount to administrative action. He says the source of power or the nature of the power in question is contractual. It's not legislative power. Therefore, the exercise of power or the performance of the public function did not constitute administrative action. However, what's extremely interesting to note is the caveat Langa attaches to the end of his judgment. He says, however, it is important to note that my reasoning does not entail or mean that the future dismissal of a public sector employee will not or will never amount to administrative action. What does he say? Under PAJA, not under Section 33 or not under the principle of legality, but under PAJA, where a person is dismissed in terms of specific legislation. And Mokgoro and Kate O'Regan concur in Langa's judgment. So neither Squehia nor Nkobo give a proper application or bring a proper application of PAJA to the assessment of Petronella Chirwa's claim. Langa, in the minority judgment, assesses her claim appropriately as she's pleaded it in terms of PAJA, and correctly finds that her dismissal does not constitute administrative action because it took place in terms of a contract or a contractual provision. Let me say this. Had her employment and her termination of her employment been governed by statutory provisions, let's say Act XYZ made provision for the way in which she was employed and the way in which she was dismissed, then I have no reason to doubt that the court would have found that her dismissal constituted administrative action, and her claim her claim probably if you look at the reasoning of Squehia, would still have been rejected, but Langa would have found in her favor, albeit in the minority. So the Chirwa case, subsequent to the Chirwa, there's been pro-Chirwa judges and anti-Chirwa judges who have found that the dismissal of public sector employees does amount to administrative action, and that even so, they must pursue their remedies under the Labor Relations Act, whereas other judges are of the view that if you have several causes of action arising from the same facts and circumstances, you are at liberty to pursue your claim in the forum in which you believe your claim should be heard and given effect to. Just as an aside, Petronella Chirwa contested or asserted that the reason she went to the High Court was for practical considerations. What would those practical considerations be? If she had pursued her claim in the Labour Court, the maximum relief she could have ever been awarded, had she claimed compensation and not reinstatement, based on a claim of an unfair dismissal, was 12 months compensation. She'd never claimed automatic unfair dismissal. You can only claim automatic unfair dismissal on the basis of, let's say, discrimination, for example. Then the maximum amount you can receive is 24 months of your salary at the time of your dismissal. So the practical considerations, in my view, and this is my view, it doesn't